So the Supreme Court now has a case in front of them which seeks review of the Illinois ban on so-called assault weapons, rifles, and then standard magazines. But the state just told the Supreme Court that they do not intend to defend this case unless the Supreme Court steps in and demands that they do. So let's talk about what's happening in this case and what significance this has. But real quick before we jump into this video, if you think the Supreme Court needs to strike down these rifle and magazine bans, go ahead and hit that like button and subscribe. Also, to mention that the Gundy's Awards are now open once again. You can vote using the links down below in the detail section and also in the pinned comment. I'm nominated once again for Top 2A Voices and then also Influencer of the Year. We won the Top 2A Voices a couple years back, so it would be cool to win again. But again, you guys can vote every single day. Voting ends December 15th, so get your votes in early and often, and you also are entered to win a bunch of prizes if you vote. So again, links are down below if you want to vote for me, but also check out all the other categories to vote for your favorite influencers, content creators, all of that. Regardless, thank you guys so much for all of your support. So like I mentioned in the intro, in this video, we're going to be breaking down an important situation that is now up for Supreme Court consideration. A petition has been filed to the Supreme Court for the Supreme Court to step in and review the Illinois ban on so-called assault weapons and then also magazines. The case we're going to be talking about in this video is called Culkins v. Pritzker. This case involves a challenge to the Protect Illinois Communities Act, or PICA, which places unconstitutional restrictions on rifles and magazines. PICA also requires a registration deadline, a requirement that you have to meet to have those rifles already in your possession grandfathered in, and then that registration period is currently set to end on January 2024. So time is very much of the essence in this case, and there's another case right now also up for Supreme Court review, which is the NAGR v. Naperville lawsuit. And in that NAGR case, we've broken that down, we've talked about in videos. They are also seeking for an emergency intervention from the Supreme Court. They filed an emergency application for an injunction in the Supreme Court. But this Culkin case, however, is also up for Supreme Court review, and it's on a more traditional writ assert petition process. So it's more of a traditional process going to the Supreme Court for review. And the state of Illinois just did something interesting. They just filed notice to the Supreme Court that they do not intend to file a response brief in this case, and they don't intend right now to defend their lawsuit in this law, which is now up for Supreme Court review, unless the Supreme Court forces them to file a response. This means that the ball is now completely in the hands of the Supreme Court, and the Supreme Court will decide how this case is going to proceed forward from here. Now, this case has some interesting background, which also might intrigue the Supreme Court even more to, again, move this case along and require that the state of Illinois file a response. This case challenged PICA in state court, so this is a state court lawsuit. The case was originally brought in an Illinois lower court who on review entered judgment against the state of Illinois, declaring that the ban was unconstitutional for denying equal protection of the law and because it was an infringement on the Second Amendment and the fundamental right to keep and bear arms. Therefore, that state lower court ruled PICA was void and unconstitutional. In response to losing that case, the state of Illinois then appealed the decision up to the Illinois State Supreme Court. Now, here's where things get interesting. The state of Illinois and their Supreme Court has 7 judges that sit and review these cases. 2 of those judges were elected recently. They were elected into office on November of 2022, and during their election process, they received substantial campaign contributions from the state governor. I believe it was anywhere around like $2.6 million in combination from the governor and various contributions in relation to the governor. And again, the governor is the one who's the defendant in this case. Because of that fact, the plaintiffs filed a petition to the Illinois Supreme Court to disqualify and recuse those 2 judges. Now, even more concerning for this specific case was the fact that those 2 judges who received those contributions, who are now on the Illinois Supreme Court reviewing this case, also during their campaigns talked about how they would potentially be dedicated to supporting any ban in Illinois, bans on rifles and magazines. So not only were they receiving money, but they were also making statements that they would uphold or protect any of these rifle or magazine bans that the governor put in place. However, on review, the Illinois Supreme Court denied the motion to disqualify those 2 judges. The Supreme Court there in Illinois found that they don't have any rules to disqualify those 2 judges. Instead, those 2 judges, each on their own, would need to determine if they needed to recuse themselves. And of course, those 2 judges did not recuse themselves from this case. And ultimately, in a 4-3 decision authored by one of those non-recused judges, which was Judge Rochford, the Supreme Court of Illinois decided to reverse the lower court's judgment that invalidated the Illinois ban on so-called assault weapons, rifles, and magazines. So the plaintiffs here, the petitioners here, have now filed a writ assert to the Supreme Court, the US Supreme Court, for them to review what happened in the lower courts and also the Illinois Supreme Court. In their cert petition, the petitioners argue that the pertinent inquiry is whether the class of firearms is commonly possessed for lawful purposes today. In this section, the plaintiffs are arguing to the US Supreme Court that these types of rifles and magazines which are banned in the state are commonly owned for lawful purposes in their millions, and therefore, under the precedent of Heller and Bruin and all the other Supreme Court precedent relating to the Second Amendment, this type of partial ban even is not permissible. And even the structure of this law, the way that it's structured, would potentially also show that the state of Illinois is banning commonly owned and possessed firearms. They also go on to point out that the registration provision creates a sunset on the right to keep and bear arms and the right to keep these types of common arms. Essentially, anyone who purchases and registers these common arms gets to exercise their fundamental rights going forward. But once the clock strikes midnight, everyone else will be left out, and the right to keep and bear arms will all of a sudden just magically evaporate for those people who don't meet the registration deadline. And then all of a sudden, magically, they're criminals, and then going forward could also be prosecuted and lose their right to keep and bear arms in perpetuity. And because of this, they argue that the law creates two classes of Illinois residents. One class will get to exercise their right in a limited capacity going forward, while the other class is essentially just out of luck and cannot exercise their right to keep and possess these types of common arms. Now, interestingly, in this case, the state of Illinois filed a notice recently, a notice of waiver, and they filed that to the US Supreme Court. In the waiver, the state of Illinois is identifying that they do not intend to file the required response brief, which is due on December 14th, and they argue that they will not file that unless they are ordered to do so by the US Supreme Court. Waivers like this happen often, but it's interesting in that in this high-profile ban on rifles and magazines, the state here is not intending to defend their law, are not intending to file a response to the Supreme Court unless the Supreme Court orders and demands that they do. And this is also very interesting because of that looming deadline. In some of these other cases which have been submitted to the US Supreme Court, like that Naperville case, which is asking for emergency application and emergency injunctions. And here in this case, the state of Illinois is taking the position that they do not intend to defend this case unless they are ordered to do so. And what this does is it puts the ball completely in the hands of the US Supreme Court. I believe the Supreme Court will order that Illinois must file a response brief. Whether or not they keep that deadline of December 14th is yet to be seen. The US Supreme Court requesting the response would further show that they are interested in some way in a rifle magazine ban, so that's something we will definitely be keeping our eyes on. And again, remember that recently in the NAGRV Naperville case, Justice Barrett ordered that the state of Illinois and then also the city there, Naperville, needed to file a response to the emergency application and the request for an emergency injunction. And so the Supreme Court has already requested briefs in one of these other cases, so I anticipate that they will still do the same in this one. This is likely just a stall tactic by the state of Illinois, but it's also interesting that the state would openly violate the residents' fundamental rights to keep and bear arms. They would put in place this hyper-restrictive law, this registration process. There is a looming deadline, but then when it's challenged to the highest court of our land, they simply take the position that, hey, we're not going to defend this unless we are ordered to do so. So this is definitely an interesting and important case. I think the Supreme Court will require a response brief in this case, and the hope is that they will ultimately step in and grant review of this case or one of the other cases. We will be watching this case and the Naperville case closely over the next coming weeks because of that looming registration deadline, and a lot of people in Illinois are not registering, so a lot of people are going to be at risk. But again, I want to temper everyone's expectations. The Supreme Court traditionally does not get involved in these early cases. They don't like to get involved this early, especially recently in these 2A cases. The Supreme Court has denied these types of requests. So again, we will be crossing our fingers, hoping for the best, but it is going to be an uphill battle. So if anything else develops, I will let you all know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. Also, I just want to mention that you might want to double check your subscription because YouTube likes to unsubscribe people. I get comments every single day that people have been unsubscribed. So just double check that. And then also, if you are subscribed, make sure you click that bell icon and turn on all notifications because that ensures that you get these videos when they are released. But regardless, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.